to go. All right. Good afternoon, Globe and Mail readers. I'm here with Daniel Lublin. He's our employment lawyer with Globe Careers. Hi, Daniel.
Hello. How are you?
Good. How about you?
I'm fine. Thank you very much. Happy to be here.
Very good. We are going to reach into our mailbag today. We have a load of questions from a lot of people with employment issues. And so we'll give them a chance to air their beefs and get a little bit of free legal advice. You ready to roll?
Fantastic. I'm good. Let's do it.
All right. Our first question is about a full-time employee who gets contracted out to other companies and has been very dissatisfied. And one of the clients has an interesting job opening that they've talked to this person about. And it doesn't relate to their current contract. And they said they would have the company backfill her current job if they couldn't replace her. She says she doesn't have, I think it's a she, doesn't have a non-compete or any solicitation agreements. And she's wondering if she can give her 2 weeks notice and join the client without her current employer trying to sue her. She's not sure her current employer could be able to backfill her position, and she's wondered what her status is. What would you tell this person?
Good question. So the first thing is that we need to check the terms of her employment relationship with her current company. And to do that, I would first need to see whether or not she has an employment agreement. And she claims that in her employment agreement she doesn't have any signed non-compete or non-solicitation. So I'd want to confirm that. That's really important. Usually when you work in a situation where you're being contracted out to third companies, so for example like a staffing company, you're asked to sign something that says that you won't take up employment with the clients, because what will happen is the client will often try to cut the staffing company out. So in my experience, you're likely to see something in writing that would prohibit her from working directly with one of the clients, which is what's happening here. So let's just assume she's correct and she hasn't signed anything that would prohibit her from doing that. So that's the first issue. Is there anything in writing that would prevent her from doing it? And you have to have someone who knows what they're talking about take a look at it, because it can be couched in different places and you can find it in different places. It's not just necessarily in an employment agreement. You'd have to look in a policy manual or anything else that she signed when she was hired, so all of the hiring documents. If she didn't sign anything that restricted her ability to work for the client, for a competitor, or to solicit anyone after she left, she is almost free to do what she pleases. And the reason I say almost is because I'm assuming that she doesn't hold any confidential information that could be used against the company that she's leaving. But outside of that, the law doesn't prevent the free flow of human resources, which is in the absence of a contract, she can go wherever she wants and she can work for the client, and that's basically bad on the employer for not having her sign something that said she couldn't do it.
Right.
So that's the answer to that. The second part of her question is with respect to her notice of resignation and how do you deal with that. So she says here, I want to give 2 weeks, and that's a myth. That the number 2 is irrelevant. What you look for when someone resigns is how long would it reasonably take your employer to replace you. So how long would it take to hire a replacement? So if she had, she's like a rocket scientist or was very specialized, obviously it would take a lot longer. And the theory of providing 2 weeks notice wouldn't apply in these circumstances. So, what I tell people is when you're resigning to work in a situation where you have some concerns like this, make sure you give your employer proper and fair written notice, and you have to consider in that notice how long it would take them to find a comparable job. So starting point is, what did she sign? Did she agree to anything that would prevent her from doing this? And number 2 is make sure she gives a fair notice of resignation to the employer that she's leaving.
Are there many employers who would keep you on if you were going to a competitor?
Mm-hmm. No, not really. And what'll happen is in my experience, what they'll do is they'll say, well, we acknowledge your resignation, but we'd like you to leave immediately. And in those cases, they'd have to pay you for the period of time that you were prepared to remain there during the resignation notice period, unless the contract says otherwise. So you can even agree. I mean, you can agree to a lot in an employment contract. That's why I often tell employees to be careful when signing them, and I tell employers to make sure you have one. So in the employment contracts that we draft up, I usually put a clause in that says that if you've resigned, we have the right to ask you to leave and to pay you only the minimum under the legislation. So it can happen, Jillian. They can say to you, leave immediately, and it could happen definitely if she was going to a situation like this where it's a client or a competitor, but the employer may be on the hook to have to pay some of that resignation notice period.
Right. What is the minimum?
The minimum of
that they get, that if you resign, what's the minimum? If they say we want to walk you out the door now, what's the minimum?
Yeah, the employer would have to comply with the employment. It's essentially considered a termination during a resignation notice period, and if that's the case, you'd have to pay statutory termination pay, and that's contingent upon your tenure. So for an employee who's been there for between 3 months and 1 year, it's 1 week, and it goes up by 1 week for every year to a maximum of 8, at least in Ontario, and it's pretty similar for the rest of the provinces and jurisdictions.
Right, right. What about non-compete clauses? Those are tricky things. What do you do in a situation like that when you're hired on? You want the job, and there might be a non-compete clause. What's your best avenue? I mean, are these sort of a done deal? I don't know how much you can negotiate those when you really want the job and you don't know. Could be 10 years till you're looking for another job, depending.
This is what I often tell people. If you can negotiate salary, you can negotiate anything in an employment contract. So the concept of people walking into a job offer negotiation and saying, I'd like more money out of the job. That concept is not unfamiliar to people, and people seem comfortable with the notion that they can negotiate on their salary. Salary is at the top of the hierarchy when it comes to things that employers care about in an employment contract. In other words, if you could go in and feel comfortable saying, pay me an extra $10,000, you need to feel comfortable going in and saying, I need to negotiate on this non-compete term. Everything outside of salary is negotiable. Everything is negotiable in the employment agreement. You just need to be able to go in and do it. So there are different ways to negotiate different terms of an employment agreement, and it's different for everyone. Some people have more leverage than other people. Mm-hmm. Executives or people that are being recruited or asked to leave one company to join another. You really have to look at what's being offered to you too. And in some cases, I tell clients, I say, you know what? I've looked at this non-compete, and on its face, it's so clearly unenforceable because of the way it's drafted. Don't even bother negotiating on it, because I don't think the employer is going to be able to ask you to adhere to it at the end. So you really need to know what you're asking for, but you need to feel comfortable asking for it.
Are they really quite enforceable, the non-compete clauses, and are they important for a company?
Yeah, they're very important for a company for certain positions. If you have someone in managing your sales or in constant contact with your important clients, you definitely want to have some restrictions about what they do after they leave. So they're definitely important for employers, number one. Number two is they can be enforceable if drafted properly. Employers have gotten a lot better and certainly more adept at preparing employment contracts in a way that would be enforced by the courts. And the courts have gotten a lot better at clarifying what employers need to do in their employment contracts to ensure that they are enforceable. So I think even 10 years ago, it was a lot more difficult for an employer to enforce a non-compete, just because many of them were drafted very properly. I don't want to give the general rule, but for the most part, for non-executives who have got a non-compete in their employment agreement or somewhere else in their hiring or employer documents, somewhere in the range of up to 6 months, I would start to say is the higher end of the length of a period of time that you can be asked to sign a non-compete for. For executives, it can go over that, but everyone's different. Every situation is different.
Right. Okay, let's go on to our next one. This one's a little bit shorter. This is someone who is currently employed and has an interview set up with a different company. But the problem is the hiring manager at this new company knows the person's current boss. What does the law say about this? Can the hiring manager tell her boss or his boss that this is, or is this considered privacy? And what happens if he tells him about the interview and then gets fired? What can you do?
So this is basically the new frontier of employment issues that I'm seeing, and there aren't really any cases that are right on point, and there's definitely not any legislation that touches directly on the issue here. What the employee needs to do, and part of it's common sense, is you need to make sure that while you have a job and you're applying to work somewhere else, your application is done in confidence. So you need to make sure when you submit the materials in that you make it clear to the company you're applying to that this is an application in confidence because you're currently employed. And if that employer accepts your hiring or accepts your application as a candidate and then goes ahead and contacts the employer that you're currently working for and you lose your job, you could hold the potential new employer responsible for that. So there almost becomes an agreement when you apply in confidence that the employer has to take your application in confidence.
How would you do that? Would you state that in your cover letter, or have
Absolutely.
a separate page or something, or how would you make that?
Absolutely. So I get applications from potential candidates to work for me all the time, and many of those people who are currently working somewhere say this is strictly privileged and confidential. I'm applying in confidence,
Okay.
and I think it's incumbent upon the job seeker to make that clear. And I did look into this a little while ago for another case I was dealing with, which is outside of an application that's made in confidence. If that doesn't happen, what can an employer do to check up on someone? And is there any restrictions from an employer looking at a potential candidate's background? And for the most part, prospective employers can take the steps that they need to do to ensure that they're getting the person they think they're getting. So you can call references. You can take a look at people's social media profiles. If someone puts on their resume that they worked for my firm, for example, and that person didn't leave me as a reference, if the company you're applying to knows me, they could call me and ask me about that individual. And that then branches off into a whole other area of law, which is something called negligent referencing. And that's why a lot of companies these days are reluctant to give very strong substantive reference letters, because you can be, although it's more exceptional, but you can be sued if the reference you provide to someone is negligent. But that's a different story altogether. So the short answer is it's a good idea, if you have a job, to make your application in confidence if you're concerned that prospective employer will call your current boss.
Now, what happened? So if you got fired, let's say your boss found out and you got fired because you were looking for a new job, who would you go after? Would it be both? That you got fired because someone gave you?
So if you ended up getting the new job, then you really only are entitled to, if you were fired from the job that you had, you really would only be entitled to your basic statutory minimum severance, because you've mitigated whatever your damages were by securing a new job. So let's assume you don't get that new job. So now you're out of two jobs. You're out of the job you had and the job you wanted. So you could go after you would go after both. You would go after the company that fired you, because it's not cause, and it shouldn't be cause for dismissal to simply apply for another job while you already have one. There's nothing that prevents people from looking for other work, as long as you don't really do it on company time, right?
Right.
Or as long as you take advantage of company resources and time doing it. So they would have an obligation to pay you severance, but you could also go after the company that went around you and called your current boss, told your current boss that you're looking for another job. You wouldn't get your damages doubled, but certainly someone there in the relationship would have to make sure that your recovery is indemnified.